Hey everybody, I'm attorney Mike Contant. Today I wanted to talk about our nation's veterans and what the courts can do to help them if they're charged with a crime. There are a number of programs in place for veterans who've been charged with crimes. And today I want to talk about a couple of the different programs. These are what they call diversion programs. And a diversion program at its essence is simply kind of like a form of probation, but if you're successful, it typically involves some type of treatment, sometimes community service. If successful, you're never arraigned on the charge. It never appears on your record, and you're able to keep your record clean as a result. And there are different diversion programs in different courts for different things. These two that I'm going to talk about today relate specifically to veterans. Now, the first program I want to talk about is called the Valor Act. Okay, that is available to anyone with what they call a history of military service. That includes a service you would normally think, the Army, Air Force, Marines, Coast Guard, Navy, of course, as well as service in the National Guard. Okay, it doesn't require you to have participated in a war or anything like that, but have that history of military service. And don't worry, that's all going to get confirmed by probation. There's nothing specific you have to bring in. It'd be helpful if you brought in your discharge papers, your DD-214 or something like that. But probation will confirm that with the Department of Veterans Affairs. So you don't have to worry about if you don't have paperwork proving your military service, it'll be able to be shown by probation. The other thing you have to have is no prior adult convictions of any crime, okay? And what I mean by adult is, anything since you turned 18. So if you have a juvenile offense for something, that doesn't count for the Valor Act, okay? It has to be no prior adult convictions for anything, okay? This is only going to apply to either the district court or the Boston Municipal Court, both sort of they call district court level courts. If you have a case in Superior Court, which is typically speaking much more serious, the Valor Act doesn't apply to any charges brought in the Superior Court. Okay, and the other requirement you have to have is that the charge itself has to be serious enough that there's potential for imprisonment. In other words, in the statute, it would say, as opposed to just $100 fine, that you could go to jail, and with all that, you could qualify under the Valor Act. Now, how this works is that when you go to court for the first time to be arraigned, prior to being arraigned, what you want to do when you check in with the probation officer, you want to tell them that you're a veteran, you have some history of military service, so they can confirm that that's true. Okay. What's going to happen from there is you have to ask the court for permission to continue your arraignment. In other words, you're not going to get arraigned that day, but you do need the court's permission to continue that arraignment and typically speaking, the Act talks about 14 days, and it can be longer if the court allows for it, but it's usually no less than 14 days. The arraignment is continued, and that's so that you can get an assessment done, and the assessment is done by either the Department of Veterans Affairs, Veteran Services, or a related health specialty. So in other words, if you have mental illness or something like that, you can get an assessment by a doctor that's approved, that's allowed and approved by the courts in order to do this, okay? And during those 14 days, essentially what's going to happen is you're going to get this assessment done. You're going to go in, talk to the particular psychiatrist, a psychologist, or doctor, and they're going to write a report. And that report is to talk about, any potential issues you have and how you could benefit from some form of treatment. And treatment is what we're talking about here. For this particular diversion program, they want to put you in, again, some type of treatment program. It doesn't mean that you're going to be locked up, during the treatment, but it's just that you receive some sort of treatment, usually outpatient treatment, whether it means talking to a counselor, a psychologist in group setting. But the idea is the report's going to outline for the judge what type of treatment might be beneficial to you. Now, the judge can review the report and they can make the decision to allow you to continue towards this diversionary program under the Valor Act, okay? From there, if they agree, they will they will continue your case for at least 90 days. And the 90-day period is so that you can try to complete this particular program. Now, let's just say the program takes longer. The particular program at issue says is a 6-month program. That's okay. You're going to come back after 90 days. Your progress will be explained to the judge by probation, by your lawyer, and it'll be, typically speaking, they will allow for further continuance and further stays of the prosecution, meaning no arraignment, nothing going forward with the case, while you're in treatment. So, and that'll happen until you get through the treatment. Now, if you complete the treatment, you get through all the treatment and the conditions that they set for you and they talked about in the report, the court has the discretion at that point to say you've completed your diversion program and your case can get dismissed, okay? It is important to understand that I say may, all right? This is not an automatic thing. Just because you do everything the court said you're supposed to do, it's still on the judge's discretion. Everything in this thing is discretionary upon the judge. If you read the law, it says the judge may give you the 14-day continuance. The judge may stay the case for 90 days. The judge may dismiss the case at the end of your diversion program. So it's really important to understand that, even though this is a law that's put out there and most of the judges subscribe to it, the particular circumstances of anyone's case could cause a judge to say, I'm not going to do that. It's very much in the judge's discretion. That's why they use the word may throughout, okay? And so that's the Valor Act in sort of a nutshell. Another type of diversion program that's available for veterans, they call it the Brave Act, okay? And this came into play in late 2018, if my memory is correct. And this had to do with because the Valor Act used to include the offense for drunk driving, for like a first offense drunk driving. And it was stripped out when they did the crime bill in 2018, which was very beneficial to a lot of people. It stripped out a couple of the crimes that were available to be done under the Valor Act. One of those crimes was for drunk driving. So they came up with this legislation to help correct that, because they do recognize that drunk driving and alcoholism can be caused in many times by a person's military service. Many times, and most of the provisions of this act are very similar to the Valor Act. You have to have that history of military service. You have to have no prior adult convictions for any type of crime. You have any open warrants or cases anywhere. In addition, one of the other requirements is that you also can't have any prior convictions for drunk driving, okay? And that could be alcohol or drugs, but any sort of drunk or drug driving, you can't have any prior convictions for those in order to qualify for that. And that includes juveniles. So if you're 14 or 17 years old and you picked up a drunk driving case, the Brave Act isn't going to be able to help you. Another requirement that is different from the Valor Act is you have to have been diagnosed with either a traumatic brain injury, okay, a mental illness, or substance abuse, which can be shown by the doctors and medical personnel to be somehow connected to your military service. So traumatic brain injury could be obvious. Maybe you served in combat and you were you're involved in some sort of an explosion, or again, were just attacked in some way. It caused traumatic brain injury. Okay, concussions, a type of traumatic brain injury. Okay, substance abuse. Again, some people suffer from PTSD, and they have to self-medicate. Okay, so they develop coping mechanisms through alcohol and drugs to deal with the different issues that were caused by their service. Mental illness sort of speaks for itself. But again, you're suffering from some form of mental illness that's connected to your military service, not something that you essentially had before, or at least not to this particular degree. And you'd have to demonstrate that by a doctor, okay? Other than that, the requirements are very similar. Regarding, continuing the case for those 14 days, to get an assessment, to show that there is some form of treatment that could be beneficial to you. And again, just like the Valor Act, your participation in these programs can, if you're successful, it could result in your case getting dismissed. Now, the one thing I haven't talked about is, well, okay, so I got into the program and the judge seems to be on board with this, but I screwed up, all right? I got kicked out of the program, or I picked up another case, or I did something I wasn't supposed to do. What happens to me then? And essentially what happens in that case, in both the Brave and the Valor Acts, is the court, again, has this discretion. They could say, you screwed up, you're getting kicked out of the program. We can give you another chance and try and get you into a different program or back into the same one. Or we can just, prosecute the case. In other words, we're going to bring the case forward. We're going to arraign you on the case, and you're going to be prosecuted just like anybody else because we gave you the chance and you didn't follow through. And this is the penalty for not doing so. And then you get to defend the case like you could in the beginning. So if you have a good defense to the case, you can bring it. The point of the Valor and the Brave Act isn't to strip you of that, but it's just to make it a little bit easier to keep this off your record and make sure the case goes away prior to arraignment if you're doing the right things. Now, the good thing to keep in mind, too, is because you're providing all this information potentially to doctors, to the courts, is that anything you said, right? So if you said anything during an assessment or during treatment that implicates you in the case, those statements can't be used against you. So they want you to be open and free while talking to both the assessing therapist as well as any therapist related to the case. So any statements you made during those assessments or anything related to the Brave or Valor Act while you're participating, they're not going to use those statements against you later if they're going to try and prosecute you in the event you did get kicked out. All right, so if you have any questions about either the Valor Act or the Brave Act, whether your case qualifies or anything like that, please feel free to leave a comment, shoot me an email, give me a call. I'd be happy to speak with you about it. And particularly, we are grateful to our nation's veterans here. My dad and grandfathers all served in the military. I didn't have the privilege of doing so, but I am grateful to all the members of the military and the veterans who've helped this country. So just a little bit of information on that. Like I said, if you have any questions, give me a shout. Happy to speak with you about it.